Well, ladies and gentlemen, thank you to everyone who's joined or is joining, and thanks very much indeed to the panelists who are on the screen. It's a great pleasure to be asked to chair the launch of this important and thought-provoking report on sovereignty and its relation to primary rules of international law. It raises some central issues of international law. It has, as you know, just been published online by BIICL. It's a project that was supported by the FCDO, though they're not in any way responsible for it. We have just 1 hour for today's meeting. That's a very short time for a very rich report, and I hope that perhaps at a later occasion an opportunity will be found to have a longer meeting, perhaps a day on the subject. We're going to hear briefly from each of the panelists, and then I hope we'll have about half an hour for questions from participants. So please think of questions as we go along and put them in the Q&A box. I'll first introduce the members of the panel. First, we have Dr. Jack Kenny. Jack is a research leader in international law at BIICL and a lecturer in public international law at the University of Manchester. He is the author of the report, which is being launched today. Second, Sir Malcolm Evans. Sir Malcolm was formerly Professor of Public International Law at the University of Bristol and is currently Principal of Regent's Park College at the University of Oxford. And third, we have Martins Paparinskis. Martins is Professor of International Law at University College London and a member of the International Law Commission. The fourth member of the panel is Harriet Moynihan. Harriet is Head of Accountability at the Institute of Technology and Justice, Blavatnik School of Government, University of Oxford, and an Associate Fellow at the International Law Programme at Chatham House. And in addition, as you see, Penelope Ridings is on the screen. Penelope is also a member of the International Law Commission. This year, she was appointed Special Rapporteur for the ILC's new topic, due diligence in international law. And I will ask her to say a word about that topic after the other panelists have spoken. It's relevant because of the discussion in Jack's study on obligations of conduct, which is an important part of the study. I propose that we proceed as follows. I'll first invite each panel member to speak for 5 or 6 minutes with some thoughts inspired by the report. After that, we will put your questions to the panel. As I say, I hope that will last about 30 minutes. And then Jack will round off the meeting with a few concluding remarks. So, Jack, could you please start us off by introducing the report in just a few words, please? Jack.
Thank you very much, Sir Michael, for that kind introduction. As the author of the report, I thought I'd begin by providing some context to the work and how it came about. In line with the approach of the research, which is focused on underlying normative issues raised by debates concerning the application of international law to new technologies, rather than on those debates themselves. I don't expect too much discussion today on cyberspace, but it is helpful to understand the significance of the research and how these issues have been brought to the forefront of discussions among states in debates about the application of international law to new technologies. During my doctorate at Oxford on the subject of sovereignty and cyber operations, I was involved in several projects on the application of international law to cyberspace. Notably, I worked as a research assistant on the excellent project at Chatham House, which led to a report by Harriet, who I'm very pleased to say is joining us on the panel today. At that time, in the early stages of these debates, we would discuss matters such as sovereignty with a relatively small group of academics who were focused on the application of international law to cyberspace. And there was a general effort in these academic projects to identify rules of international law that apply to cyber operations below the threshold of a use of force, perhaps at times quite creatively so. And some of these projects, including those involved in capacity building processes, have had a remarkable influence on the positions adopted by a number of states that have now come forward and released statements on the application of international law to cyberspace. Now, I was fortunate to receive excellent supervision for my doctorate, and something that quickly became apparent upon close examination was that many of the normative claims that were prominently argued in the cyber context were not necessarily straightforward in terms of their legal basis more generally in international law. The approach taken was that since existing international law applies to cyberspace, one must identify rules or obligations in general international law, and then those rules would be automatically applicable to cyber operations. And central to these normative arguments advanced in this context, and which is dealt with in the report, is the contention that sovereignty is a rule of international law, a rule of customary international law, such as that if it's violated, it's capable of establishing state responsibility. It's also been argued that international law imposes a general obligation on states to act with due diligence to prevent their territory from being used for activities that harms the rights of other states, where this obligation is not confined to particular forms of activities. Working at BIICL after completing my doctorate provided an opportunity to engage further with experts on the issues raised by the research. And the idea I had really when proposing the project was to take some of the normative claims being discussed in the cyber context and engage with both general experts in public international law and those with particular expertise on the relevant issues, including sovereignty and due diligence obligations, outside of this specialist cyber debate. And in that sense, the goal of the research and of the report is to draw attention to and to encourage the discussion of these normative issues, especially in light of the significant implications that some of these positions entail beyond the cyber context when states are adopting them. And at the same time, due to its focus on underlying issues rather than on the cyber debate specifically, the hopes that this research will be useful to those that are working in international law more generally, including in areas that might touch on these questions. In line with these aims, the report was structured and informed by engagement with experts and practitioners through a survey and semi-structured interviews, and finally with roundtable discussions. And it draws on this engagement to inform its content and its conclusions, with additional support provided by an examination of relevant sources of international law. In many ways, the findings of the report might not be surprising, at least not for those unfamiliar with the unusual nature of some of the claims that have been advanced in the cyber context. But I dare say that there's always something to disagree with on subjects as vague and as contested as sovereignty. Sovereignty is extremely difficult to define with any clarity. It's a concept which is contested, and that means different things to different people. One assumption I had going into the report was that there was a relationship between sovereignty and primary rules. In fact, the title of the report was originally Sovereignty and its Relationship to Primary Rules of International Law. And the relationship was changed to relation as the research went on, and it became apparent that even stating such a direct relationship exists was controversial, or that it needed to be carefully qualified. We can, however, find some agreement on common views. For example, there are popular views that sovereignty is an underlying concept or organizing mechanism of international law, or that it is an underlying concept comprising rights and duties, whatever those rights and duties may be. To some extent, it's also possible to find common ground on the status and function of obligations of conduct, due diligence obligations, or at least disagreement over particular interpretations in relation to a general obligation to prevent harm. I've learned an incredible amount about sovereignty and about the nature of international law more generally since undertaking this project in 2023, perhaps far more than can be conveyed in a single report. So I welcome Sir Michael's comments about possibly a longer discussion about its contents. But I hope the report has managed to capture many of the interesting insights that I encountered, which were all made possible by those who so kindly gave their time. And I hope this sets us up for some context about the research and why it was carried out. And I look forward to the discussion on the issues it raises.
Well, thank you very much, Jack. I now ask Sir Malcolm Evans to start off the discussion. Please, Malcolm.
Well, thank you very much. And I've been asked to begin this discussion with some quite broad general reflections on this fascinating, thoughtful, and in some ways provocative report. And as time is short, and as my fellow speakers do fascinating and thoughtful far better than I do, I thought it was best to limit myself to being provocative. So that's what I will do. One thing that the report is quite clear about, or seems to me to be fairly clear about, is that it's not really possible to be clear about what sovereignty means in and for international law. This is somewhat disconcerting, as another thing that the report seems to be clear about is that sovereignty is most generally and possibly best understood as an organizing principle of the entire international order, rather than something from which discrete rules can be distilled. Such rules might reflect or be inspired by sovereignty, but sovereignty itself does not do so. Perhaps as Kelson absolutely did not say, sovereignty might provide the grund, but it doesn't provide the norm. Nevertheless, it is the basis on which all else apparently is to be founded. Now, what does this tell us? To be honest, probably nothing that we did not already know, or at least intuitively know. So let's step back for a moment and pick up on something we international lawyers love to say, but rarely love to do, which is to focus on the ordinary meaning of the term. Now, sovereignty is not a thing. I would argue that sovereignty is a claim to authority and to power. It is, in other words, little more than an assertion. If, and this is a big if, for those in the UK, ask King Charles I, if this claim, this assertion is accepted by others, and accepted for whatever reason, I may no comment on that, then it acquires a reality that it previously did not possess as a mere assertion. It is reciprocal, though usually asymmetric. It is this reality of sovereignty that we are, or should be, concerned with, as that reality is accompanied by what we might call, or I suppose I choose to call, attributes, things that flow from it. These will be different in different contexts. After all, sovereignty isn't only a concept known to international law. But in the sphere of international law, possibly we could suggest that the chief attribute that sovereignty, at least today, confers is international legal personality. This usually, but importantly, not always, involves statehood, and let us call it the ability, if not always the full capacity, to be a participant in the international legal system. Sovereignty, then, is what the holder of an entry ticket into the international legal order is described as having. No more and no less. The snag is that we have become used to thinking that it does confer more than this. And this is where we get provocative. Obvious examples include ideas such as sovereign equality or permanent sovereignty over natural resources, to use two of the more well-known phrases in which we find it. In the ordinary sense of the word, I think we know that both these statements are fairly obviously untrue. Sovereignty implies neither equality nor permanency over anything in the ordinary sense of the word. Sovereigns have never been equal or permanent, but this does not mean to say that they have not been sovereign whilst they have been a sovereign and understood as being sovereign in relation to those areas or matters over which their sovereignty is accepted. But today, international law provides a different context and object and purpose in which to understand sovereignty's ordinary meaning. And I'm sure you will all get the reference to the wording of the Vienna Convention on the Law of Treaties. Yet there is something worryingly, let me call it, tectonic about our approaches to sovereignty as international lawyers. Too often it is portrayed as all or nothing, whilst knowing that as the plates move, bad things happen if you're into earthquakes. Yet at the same time, we international lawyers, perhaps paradoxically, are more than content to accept ideas such as common but differentiated responsibilities, and for human rights obligations to be tailored to circumstances, And as for the law of the sea, my old favourite area, we easily accept the interplay of jurisdictional competencies necessary to ensure the effective ordering of the oceans. After all, it's a different context with different objects and purposes in some ways. Sovereignty at sea is at best a limited idea, and that is before we start to think about common heritages, global commons, and so on. So, being provocative, where does this leave us? Perhaps rather than reading too little into the organising principle of sovereignty, we may already be reading in a little too much. Perhaps we ought to be thinking a little more about what justifies acceptance to claims of sovereignty and about the attributes that international law confers upon those whose sovereignty is accepted. This may offer different and arguably preferable ways of addressing emergent concerns in an increasingly interconnected and interdependent world and world order. Nothing is forever, and things do change, even ideas of sovereignty. The question is not whether, but when and how. And as I conclude, I thought it might be interesting to end by sharing the outcome of a recent Google search on the Treaty of Westphalia. Its new AI tool tells me that, and I quote, "The Peace of Westphalia is often described as the foundation of the modern international system, characterized by the concept of sovereign nation states." And it also says, "The treaties established the principle of Westphalian sovereignty, where each state is considered sovereign within its own territory and is not subject to the interference of other states." Sounds familiar, I'm sure, and doubtless it did, ultimately. Not that the treaty has much to say about sovereignty, however. Do a word search. It's mentioned 9 times in a very long treaty text, sometimes describing the count of this or the count of that as being sovereign now and then. And there are occasional references to the jurisdictions and sovereignties of the odd town or of a random bishopric. Nothing particularly significant or consistent. In other words, it wasn't even an organising principle. How things change. Thank you.
Well, thank you very much indeed, Malcolm, for that provocative and sceptical view. I remember when the Brexit debate was all about how the European Union had taken away our sovereignty. I used to say, well, it's as though we're school children playing with a football and the EU's somehow taken it away. It's not quite like that. And I'm sorry to hear that you've sold out to AI, but it sounds like AI gives quite good answers sometimes. Anyway, I next invite Martins Paparinskis to say a few words, no doubt also provocative and skeptical. Martins.
Michael, my mandate is to take the title head on and to say something about sovereignty and its relation to primary rules of international law. And so I'm very fortunate to follow Sir Malcolm, and I can take as read his skillful canvassing of different meanings of sovereignty, domestic constitutional law, political philosophy, organizing principle. And my overall drift, I think, will be to look at sovereignty within the context of the report, where I think it's really invoked in a more, as it were, the real world sense of sovereignty as an argument to be made in the making and settlement of disputes about international law. The short version of what I want to say is that sovereignty, in my view, is essentially agnostic regarding existence, scope, and content of a particular primary rules. Well, I think that is actually something that Jack quotes me in the report, so it would be a bit awkward if I were to take a different view. So I'll be consistent and non-provocative, at least in that sense. A slightly different, slightly longer version has 3 points. The first point is that I would perhaps approach with a degree of caution the proposition that sovereignty as such is dispositive of particular primary rules, even if they are viewed as closely linked to or derived from this concept. Ultimately, primary rules are to be determined and identified by reference to the normal means of determination and making of international law. And I think the point that the identification of particular rules is, as it were, removed at least by one layer from sovereignty, is reflected in various bits and pieces of international law that are usually quoted here. So Palmas, for example, sovereignty signifies independence, or signifies as the operative word, and it's independent in its own turn that carries certain rights. ILC in 1949 adopted draft declaration on rights and duties of states. First 13 draft articles go on discussing the rights and duties, and only draft article 14 nods in the very end to the principle that the sovereignty of each state is subject to supremacy of international law. So distinct analytical perspectives. Friendly Relations Declaration. Each state enjoys the rights inherent in full sovereignty. Again, a different layer. And even when the arguments are engaged with, and I think here thinking particularly of the International Law Commission, even when the argument is about concepts and rules closely connected to sovereignty, these are the normal methods of international argument that prevail rather than a priori derivations. So one example comes from the Immunity of State Officials project, where draft Article 3 looks at persons enjoying immunity ratione personae, so something very closely linked with the idea of representation of sovereign, but the argument is really does not turn on a particular conception of sovereignty. These are normal questions of international law. The second point, I think that might be somewhat alluded to by Sir Malcolm in the concluding parts of his talk about equality and permanent sovereignty, is the idea that actually even foundational rules in contemporary international law closely connected to sovereignty are not necessary, in a sense that we can perfectly imagine a legal order organized by sovereign states that has primary rules with very different content or no primary rules at all on the issue. So take such relatively recent international legal orders as the Versailles legal order, and looking at the rules set out in the Friendly Relations Declaration, one will immediately appreciate that sovereignty is consistent with international legal order that has no or very limited rules on interstate use of force, prohibition of non-peaceful settlement of disputes, self-determination, and sovereign equality. And so if sovereignty is agnostic on the policy choice of going one way or the other, that I think reinforces the point that these are different levels of analysis. My third point is perhaps one of understanding. There's nothing wrong, and in fact, it makes good tactical sense to frame claims about international law in terms of sovereignty and sovereign rights, to demonstrate in early stages of making of a particular field how it is consistent and coherent with the overall structure of international law. Such was always the case. I mean, not going back perhaps quite to Grotius and Selden, if one thinks of foundational bits and pieces of the international continental shelf, an essential question for international community, whether to view continental shelf as reflecting sovereign rights, as UNCLOS ultimately did, or based on occupation, as one of Sir Michael's predecessors thought in the interwar years, or air law, whether it is based on the ideas of freedom of air, as Faucheux suggested in early 20th century, or as Chicago Convention suggested, sovereignty. Neither of those are wrong. They are both perfectly consistent, and whoever is right turns on the normal methods of lawmaking. So in short, in my view, reinforcing a degree of caution about deriving too much from sovereignty itself. Now, it doesn't mean, of course, that sovereignty is irrelevant. Sir Malcolm made the important point that sovereignty tells us to whom rights and obligations appertain. Sovereignty also tells us who counts for the purposes of lawmaking. ILC has said something on that in its work on customary international law and general principles of law. But ultimately, sovereignty is essentially agnostic on its own regarding particular primary rules. And that is that for me.
Thank you very much, Martins. Now, Harriet, please.
Thank you, Michael. And thank you very much for having me, I should say, to BIICL and Jack. As Jack has raised the cyber context, I'd like to focus particularly on discussions about the legal status of sovereignty and how sovereignty is considered to apply, which is a topic of some debate in the cyber context. And as we'll see, some of the positions that have been taken in the cyber context are quite different to what we see in the BIICL report. And I'd like to touch on a few factors perhaps behind that as well. So in the last 10 years, over 100 states have published official positions on how they consider international law to apply in the cyber context. If we factor in regional statements by the EU and the African Union and individual statements by about 34 states now. And these statements are typically broad in scope. They cover a lot of different areas of international law, including not only sovereignty and due diligence, but other areas as well. And from these official positions, as well as official reports that are coming out of the UN cyber process in the first committee, it's clear that there is broad consensus that sovereignty is a fundamental principle that applies in cyberspace. But there are rather differing views as to whether sovereignty is a standalone rule or merely a guiding principle, and also on what constitutes a violation of sovereignty. And these questions are consequential because the answers have an impact on a range of other legal issues, including the legality of extraterritorial law enforcement measures that a state might want to take in relation to unlawful cyber activity emanating from another state, and also in relation to the legality of surveillance measures within foreign networks. Now, interestingly, for this conversation, the majority of states that have expressed a position in the cyber context consider sovereignty to be a primary rule of international law, violation of which does give rise to responsibility for an internationally wrongful act. That view has been adopted by the EU, the African Union, and many individual states. Another view is that sovereignty is merely a guiding principle, albeit a fundamental one, of international law, not a primary rule, at least not in the cyber context. It hasn't yet, as it were, become sufficiently clear to be a cyber-specific rule. And this view, which accords generally with, I think, what we've been hearing from the other speakers today, this more sort of general concept of sovereignty, is propounded by the UK. Now, some other states, including the US and Israel and Australia and just recently South Korea, have noted that sovereignty applies in the cyber context, but they haven't commented definitively on its legal status or exactly how it might be violated. And many states have noted the complexity of this issue, which I think is very much brought out in the BIICL report, and the need for further thinking on it and discussion on it. For those states that do consider sovereignty to be a rule, there's a really wide range of views about how that rule might be violated, because of course there do need to be some sort of parameters to the rule. The majority of states take the position that only cyber activities with certain effects will constitute a violation of sovereignty. And within this camp, there are debates about the sort of kinds of effects that might violate sovereignty, whether that might be, for example, the permanent destruction of a computer or simply disabling the functionality of a computer, or whether it might be usurping the inherently governmental powers of a state, maybe, for example, cyber interference in an election. But it's fair to say there's currently no agreement on the exact criterion and required threshold to qualify a cyber operation as a violation of sovereignty. Some states do not consider that violation of sovereignty depends on effects. They seem to think that any unauthorized cyber penetration by one state of another state's territory could potentially constitute a violation of sovereignty. The African Union has come out with that view, and France and Iran appear to take that view, although their positions are somewhat ambiguous. Just briefly touching on the reasons why we might have this difference between the views we have in the BIICL report and some of the views we're seeing in the cyber context, I think it is important to note the unique features of cyberspace and the distinctive nature of the threats. In the kinetic world, there aren't many occasions when one needs to consider sovereignty in terms of the obligations to which it gives rise and whether it can be violated. Usually activities are captured by a primary rule flowing from sovereignty or related to sovereignty, such as the principle of non-intervention or the prohibition on the use of force, or by a treaty in the relevant subject area. And we've heard about UNCLOS and some of the air conventions. But there are there not, and this is a question, a few examples, such as one state sending law enforcement officers into another state's territory without consent. By contrast, in the cyber world, cyber operations take place every day all over the world, often remotely rather than through a physical presence on the territory. So in cyberspace, activities violate the rights of other states very often, taking different forms, and they have a wide range of consequences. And furthermore, some of these, what we call low-level cyber intrusions, which don't obviously reach the level of an intervention or a use of force, can be very harmful in effects. We might think of indiscriminate ransomware attacks like WannaCry in 2017 that took out, had a massive effect on NHS trusts, over a third of them. So I think there's a desire by states to somehow regulate this kind of low-level, persistent and very harmful behavior. And I should just flag briefly sort of two influential factors in the thinking of states on this. So I think one is the Tallinn Manual on the international law applicable to cyber operations. That's Tallinn 2, reflecting the views of an international group of experts, which came out in 2017 and stated that cyber operations can constitute a violation of sovereignty. That manual has been very influential on several states, and it's actually referenced directly in some position statements or indirectly. And then the other factor is the case law of the ICJ, which several states reference in their official positions. In certain cases, the court does appear to consider violation of sovereignty separately from the use of force and intervention, and consider it to have legal consequences. And this has been influential for some states. So to conclude, the growing use of national statements in the cyber context to express states' views raises questions about their normative function and whether the official positions are creating, intentionally or not, a form of lex specialis of international law tailored to the cyber context. And if it doesn't, then what is the implication of these emerging positions for the interpretation and application of international law, including on sovereignty and due diligence outside of the cyber context as we're discussing today? I'll leave it there. Thank you.
Well, thank you very much, Harriet, for a very clear picture of what's a very interesting field and one I don't understand at all. I hope that those working on Tallinn 3 will have regard to Jack's report. Now it's a great pleasure to invite Dr. Penelope Ridings to say a few words about the International Law Commission's new topic on due diligence, but also more generally, if you so wish. Penelope.
Thank you very much, Sir Michael, for that introduction. It's a real pleasure to be asked to say a few words on my topic, which has been placed on the active program of work of the International Law Commission. I will only say a few words because I know that you will want to get to questions. So my point of departure is what Dr. Kenny said in his monograph, that the normative status of due diligence obligations remains vague or unclear in the contemporary practice of international law. And it is exactly this lack of clarity that I wish to explore in this topic. So due diligence, as you all know, is featuring in today's international legal discourse on addressing matters as diverse as climate change and cyberspace. But there are differing views on how to articulate the normative aspects of due diligence. So the International Law Commission, as you will know, is mandated with the codification and progressive development of international law. Because of its diverse membership and its relationship with the UN General Assembly, it's ideally suited to undertaking a comprehensive examination of due diligence. And so this project will take place over several years, and it will draw together the extensive state practice, judicial decisions, and writings on due diligence in the various specific fields of international law. And through this, the intention is that the Commission will seek to gain an articulation of due diligence as represented in state practice, and in order to facilitate the development of guidelines to assist states in their practice of due diligence in international law. So in this process, I will be looking to engage with scholars and practitioners interested in due diligence, and therefore very much welcome this opportunity to let you all know of this work. And so I would like to thank BIICL for, and Dr. Kenny and Sir Michael for giving me this opportunity to inform you more about the topic of due diligence. And I hope that we will remain in touch as this work proceeds. Thank you.
Well, thank you very much indeed, Penelope. I was going to invite the panelists to comment on what each other had said, but I think we'll skip that stage and move straight to the questions and answers session. Jack has kindly offered to help select questions or even compose the questions, and I'd invite him to start that if he's in a position to do so. Otherwise, I'll ask him a question. Jack.
Thank you, Sir Michael. Yeah, well, in that case, I do my best to try and collate these questions rather quickly. There's a question for Sir Malcolm, which relates to his presentation, and in particular, discussing sovereign equality and permanent sovereignty over natural resources, expressing the view that perhaps sovereign equality is more readily understandable as a concept, but asking whether with permanent sovereignty over natural resources, whether we know what that really means, whether there's anything concrete that it enables or disables states from doing. So I think, shall we take them in a number of them perhaps and then respond? I think that might be best.
I think that would be better. Take 2 or 3 and then people have time to think about it, or even to overlook answering if it's too difficult.
Very well. And then we have a question perhaps which is more for Harriet, which I think asks really the question which perhaps you concluded with, Harriet, which is, and I think if I recall from the discussions in the roundtable, which there's an event report of online which informed the report. One individual said, well, if we do have these obviously very divergent views of what sovereignty is outside of the cyber context, but then we look at what states are saying in the cyber context, well, what does that really mean when we have such difference of views, and what are the consequences in terms of whether that's forming perhaps a rule of custom which is specific to cyber. So I think if we take those 2 and one final general question, which I think is for everybody, which relates to sovereign immunity, and perhaps sovereign immunity being underrepresented in these discussions, or something which is quite a tangible manifestation of sovereignty. So I don't know if anyone wants to make any general comments on that.
Thank you very much. Well, I'll take them in that order. So first Malcolm, then Harriet, then anybody else who wishes to speak. Malcolm.
Well, thank you. And just briefly, yes, I did think about whether to say a few words about sovereign immunity, but in the end, time prevented, and I didn't think it necessary. To go back to the point about my line about no such thing as permanent sovereignty over natural resources. Once again, I think when the idea of permanent sovereignty over natural resources came to the fore, it was in a particular moment in a particular time, and it reflected a very real concern of the international community at the time about what new states, shall we say, on decolonization should be able to benefit from, and I think it clearly had a sort of a meaning at the time. But just stepping back to to what it means, what does it mean in this day and age to say one has permanent sovereignty over a natural resource? At the most glib level, if you dig up a resource and sell it to someone else and it's utilized, it is no longer permanent and you haven't got sovereignty over it. What is it meant to convey to us these days? I'm not entirely sure. And again, it rather begs the question about what we mean by natural resources. Our understanding of them is changing, out of all recognition. What is even a natural resource? I think, underlying these points, and also the point about immunity as well, I suppose my chief comment is, what does describing equality, permanency, or immunity, how does this change if you just add the word sovereignty to it? really adding anything that wasn't there before? If we are talking about the equality of states, state jurisdictions, the immunities of states, or those on whom they confer it, etc., etc. So perhaps it's a narrow point, but I'm just but you know, we spend so much time talking about sovereignty. Is it what does it actually do for us? What does it bring to the table?
Thank you, Malcolm. I suppose the more common term these days is state immunity, which is a way of getting away from the word sovereign. That may be why it's more common. Harriet.
Thank you, Sir Michael. So Jack raised the question about, I suppose, the difference of views between what's happening in the cyber context and discussions of sovereignty and the sort of broader discussions outside. And I suppose the extent to which the views in the cyber context might be influential, sort of more broadly in international law. So that raises the question about the status of these official positions, which are relatively unusual, as I understand it, for states to come out with sort of such broad and deep views on a particular subject area in such numbers. Well, they're mostly silent about their status and they don't really talk about what their aims are. Some of them mention trying to clarify the law, but it has been sort of discussion about the idea that these aren't merely policy positions, that they do actually reflect opinio juris, but do they reflect state practice? Often, most of the time when malicious cyber operations are attributed to a state, the state making the attribution doesn't mention international law or does so only in a very, very general way. It doesn't say this is a violation of sovereignty. So I think there are questions about their legal status and particularly whether they have any sort of weight as state practice, but they seem to have some legal weight. But does that mean that they're creating some kind of lex specialis? I think at this stage, I would say that we're really still at quite an early stage of these discussions, even though we have many states that have come out with some views. As I noted, some of those states have said that they're thinking further, and these are very complex issues, which I think is being recognised both in the report and today. Some states have not yet come out with their views, and many of the states that have are Western, although of course we do have the views of the African Union and some other states. And I think that there's not yet sufficient agreement, as I've made clear. There's a lot of diversity of views on what any sort of understanding would look like in the cyber context. And so I think it's important that we keep this debate going. I completely agree with Sir Michael's idea that we have a further discussions on sovereignty. And I really like the idea of Dr. Penelope Riding's ILC report and the idea that we might come out with some kind of principles on due diligence. And I think that would be very helpful in the cyber context, because I didn't mention much on due diligence, but we've got the same issue in the cyber context on due diligence as we have on sovereignty, really. Some states think that it's a binding obligation, either ancillary to sovereignty or in its own right. Other states are quite disagree with that and think that it's more of a principle and an expectation, that's a matter of policy. But there are debates even within those that think that due diligence is a binding obligation about what the standard of knowledge would be. Is it actual knowledge or constructive knowledge of malicious behavior on the territory? What would be the activities required? What kind of activities to live up to that obligation? So I would conclude by simply saying it's a bit unclear at the moment. There's lots of debates to be had, but what I do think is quite encouraging is that we have all these states talking about international law. There was an article in The Guardian recently saying that international law was dying, and I think that perhaps this significant engagement by states on the issue is quite encouraging.
Thank you. Martins, Penelope, do you want to add anything at this stage?
If I may,
Please.
So I quite liked what Sir Malcolm said. I suppose the question about the importance of terminology and careful read on what legal and rhetorical work sovereignty is doing in a particular context. Really just flicking through the jurisdictional immunities judgment. So that I think is an example where sovereignty and sovereign equality provides, as it were, the constitutional architectural context where particular rules fit. And ultimately, determination of the rules really would be determined in a way that it wouldn't really be influenced majorly whether or not that framing was there or not, as it were, just putting it in the right way on the cupboard. in other settings, I think the sort of examples that I had from Continental Shelf or Chicago Convention article, one seemed to me to be the examples where there are actual, again, rules with a very particular content in a specialized field, where adding sovereignty, so what the added value would be, would perhaps simply emphasize the importance that is attributed to the particular rule or particular institution within a certain field, but they don't really tell us a great deal about what the content of that rule is. And I thought that was quite interesting in Harriet's intervention, how ultimately a great deal of questions about the determination, application of particular rules are not really solved in a priori terms, that there is reasonable disagreement in statements by states on the matter. So I think that there is, a great deal of terminological accuracy. We noted in the pre-discussion that perhaps we'll know a great deal more about, well, perhaps not quite by this time tomorrow, but by this time and 3 hours after this time tomorrow, about due diligence. But I think that the International Court has been quite careful over the years in qualifying due diligence in various terms. So in the Bosnian genocide case, for example, it used the moniker notion of due diligence, which I think is a significant one as well. So I think perhaps just the normal lawyerly way of being careful and appreciating that sovereignty can do a great deal of different work is the, I suppose, the overall tenor that should inform one's approach here.
Thank you. Well, we may be a little bit wiser tomorrow. I think what it does show is that this is a fast-moving field, and this report is going to be part of a process, because it's a whole area which is developing all the time, and new events are happening. Penelope, anything to add at this stage?
But just simply to pick up on what Harriet and Martins have just said, what I find very interesting is the way in which states are now putting out their views on especially how international law applies in cyberspace. I also think it's not only the judgment that we will see tomorrow in the advisory opinion on climate change, but also the extensive pleadings in not only the ITLOS, also the ICJ, but also the Inter-American Court of Human Rights on climate change, which have almost all of them raised due diligence. And so we are now finding a rich treasure trove of state views on how they see the application of due diligence and the various issues that Harriet has raised, such as the threshold and the degree of knowledge and issues such as capability. So all of these, I think, will be very interesting to consider in greater depth. Thank you.
Yes, indeed. Thank you very much. Jack, I think we have time for at least one more round of questions if you have sorted out some
Yes.
spicy ones. Thank you.
Yes, thank you. Well, we have a few questions, and these I think are quite general. So perhaps for any speaker. First of all, we have a question about cases of the International Court of Justice, which has been mentioned in discussions already. A question about what happens where we do have the court referring to using the language of violations of sovereignty, and whether that necessarily is accompanied by violations of particular primary rules. The report does deal with this in a specific section, looking at the practice or looking at the judgments of before the International Court of Justice which have been raised or discussed in this way. So that was quite a central focus of the debates we had in roundtable discussions and in the interviews that informed the report. A further question raises possibility that sovereignty might be more than one notion. Are there different notions of sovereignty, for example, territorial sovereignty, decisional sovereignty, digital sovereignty, and what would be the difference among them? I note that digital sovereignty is discussed in different ways, for example, reference to data sovereignty, etc. The EU sometimes discusses sovereignty in a way where they're not talking about this position, which has been referred to in terms of it being a rule. And finally, a comment, which is perhaps rather than trying to define exactly what sovereignty is, it might be more useful for a future discussion to consider what the powers, attributes, and duties which either comprise the concepts of sovereignty in one view, or which can be considered as separate primary rules under another view.
Thank you very much. I would add a question, and this wasn't the one I was going to ask you, Jack, which is whether events in the course of the last few months this year would lead to any changed attitude towards sovereignty. It could be thought that sovereignty is now the only thing that matters in the world, or that it doesn't matter at all. I don't know. I just asked the question. So who would like to start with this second round? Second, and I think probably the last round we'll have time for. Harriet.
Thank you, Michael. Well, the question about the cases at the ICJ, I think, is very apposite. As I said, it's been a big point for, I think, many states in the cyber context. And cases like Costa Rica against Nicaragua do appear to consider sovereignty separately and talk about the violation of sovereignty and talk about legal consequences as a result of that. Now, the report, I think, provides some very useful nuance and color on these cases that are often cited in the cyber context. And I think personally, I do think there seems to be, this seems to have weight, these ICJ cases. So I'd be very interested in what the other speakers think about this, while noting the sort of nuance that's added in the report. On the different types of sovereignty, yes, I think there are lots. I think I do sort of think that it's useful to think of sovereignty as a bundle of rights, and it is, as we've heard, it's very multifarious and vague sometimes and complex. For me, the issue is not so much the nature of sovereignty, but when we're looking at the rights, what are the corresponding duties and obligations? And if they are obligations, how are they violated? These are the kind of issues that are coming up in the cyber context, because a lot of the activity falls below the principle of non-intervention, and yet is still very harmful. So it's that sort of issue about, is there a corresponding obligation to all of these rights that we've been talking about? And then I would agree with Michael that, it's very interesting, the history of sovereignty and the way in which different states geographically perceive sovereignty, which I think the report very well brings out, and which is also being reflected, I think, in some of the official positions in the cyber context.
Thank you. Who next? Martins.
Thank you, Michael. I mean, I overall agree with Harriet, is that we have, of course, to take the international court judgments as subsidiary means of potentially considerable weight. I think probably also appreciating the possible generality that is thrown by language in a particular case as it related to a particular specialist field, as it was argued. And without expressing an overly strong view, I would probably incline the direction that territorial disputes do reflect the sense of sovereignty being, in the very island of Palmer's case, being particularly closely interlinked with independence and territorial competencies and those matters. So perhaps there might be the slightest possible caution of deriving excessively broad propositions from that. But equally, I mean, the International Court no doubt looks at these matters very carefully when drafting, and that was a language that was used, including in the dispositif. Yes, I think that would probably, I think it's really only just to reiterate the agreement with the points made that there are different terminological meanings used sometimes, as it were, making forward a claim of what a potential rule would be, sometimes describing rhetorically a rule, the content of which one might actually agree on to simply emphasize its importance, and sometimes it were to pitch in a particular direction, or suggesting either the higher or the lower benchmark. And I guess really the question is whether how much the quality of a legal argument and identification of consensus is improved by introducing sovereignty compared to if one were to be looking at the normal means of determination of customary international law or general principles of law, as the case may be. I leave that as an open-ended question. Thank you, Michael.
Thank you very much. I liked Harriet's reference to the nuances in the report about the Costa Rica-Nicaragua case, I have to say I think that was quite diplomatic. Basically, the report says it was wrong, is my reading of it. But I pass on now. Penelope, anything to add at this stage?
No, I won't add anything because I know you're running out of time, and I want to give Sir Malcolm an opportunity to say something, which I'm sure he'll be very willing to.
Malcolm, please.
Well, thank you. How can I resist after that kind invitation, Penelope? Simply to say that, yeah, I'm in heated agreement with just about everything that everyone has been saying about the way that this plays out in practice, really. I think it's important to think about what does the use of the language of sovereignty here do. I think it does two things that possibly pull in different directions. On the one hand, it does lend a solemnity and a dignity to a position that is being put forward. And imbibes it with a sense of, I suppose, gravitas. If a state is saying this flows from its sovereignty, it puts that into a different context. And we certainly see this in terms of the debates within the cyber, but not only the cyber sphere. In a sense, it ups the ante also within those discussions, which is the other side of that coin. It can have a polarizing effect too. When people retreat into the language, as Sir Michael pointed out earlier, we've had our retreats into the language of sovereignty in debates on all sorts of things of late. It can have a polarizing effect, and this can be unhelpful for the resolution of international disputes and tensions too. And so I think the context in which it is being used and how we use it does become very important. And rather than, I think we do need to both contextualize and deconstruct it, in these fashions. As a result, yes, sovereignty will mean different things in different contexts. It's come to mean different things in different contexts. But at the end of the day, I think the key question is, does it really help in the should we say, in the generation of the primary rules and in the interactions we have around the primary rules? And does it really do much more than lend this general framing to the international order? And for myself, I'm increasingly finding that the use of sovereignty muddies debates over the content of primary rules rather than helps clarify them. And I think we'd be better off sticking to the rules.
Thank you very much, Malcolm. That sounds very wise to me. While everyone was speaking, I was wondering whether sovereignty isn't the opposite of international law. It's a sort of denial of international law, as a general description of sovereignty. But perhaps we better not go too far down that line. Now, I apologize to all the participants online if we haven't been able to get to your questions, but this is a very short session, and I'm sure Jack and all the others online would be very interested in hearing your questions. We hopefully can look at them anyway, and do contact Penelope, do contact Jack, do contact all of us, particularly those dealing with Tallinn 3, to explain your views. That would be very good. So in the minute or two remaining, I'd like to invite Jack to exercise his sovereign right to say some concluding words and conclude the meeting. Jack, over to you.
Thank you. Well, I'd like to express my thanks to Sir Michael for the job he's done in chairing this event, and also all to the speakers for all their valuable insights. It's really been a pleasure. I too wish we had a longer opportunity to explore these issues. It's been great to expand on some of the normative content which has been discussed by the report, and in some respects today's discussions added further layers to the research, so this outcome itself is really important. My thanks also go to those at BIICL who've assisted in the work, in particular Kristen Hausler for her support, and also to the events team there. And finally, I'm most grateful to the FCDO for supporting the project at BIICL. And I would also like to mention that separate to this report, on a different topic, there will be another report coming out shortly. To the audience, thank you very much for your time. We hope you enjoyed the event. And if you did, please have a look on our website on the events page for anything else that may be of interest. And so thank you very much. I hope everyone has a good rest of their day or night, depending on time zone, I suppose. Goodbye. Thank you.
Thank you very much to everyone.